Hi everyone, we'll just wait until we've got everybody in and then we will make a start.
Good morning, good morning.
They're creeping in slowly.
Well, it is 9 o'clock on a Tuesday morning on a very miserable, rainy day.
Yeah, it's not great, is it?
Good, we've got a steady number.
Okay. It's still going up.
By the way, you probably know this, but we can see the number of participants going up, and I'm not sure how much time we want to.
Yeah, we might as well.
What to say, Louisa? You're not we're like, oh, there's a raised hand.
Oh,
You can put questions in the question and answer, and we can answer any questions there, or in the chat.
Yeah, please put questions in the Q&A and put anything in the chat if there's anything you want to say. We can view the raised hand, but because we're in webinar, we can't see anybody. I should also say before we get started, and Joe and I'll introduce ourselves briefly in a moment, that it is Joe's birthday. So I do have my balloon here to wave. So I'm not going to sing happy birthday because it will only be me, but can we all just send Joe birthday wishes?
Thank you, thank you. Not getting any younger. Oh, in Welsh, is that Welsh? How lovely.
Brilliant. Well, do you want to start by introducing yourself, Joe, and then I'll introduce myself and then we can get started and I'll share the slides.
Oh, that's lovely. You make me cry, you lot. Stop it. I'm Jo O'Sullivan. I'm an accredited mediator and I wrote a book, which you must buy, obviously, if you haven't already. Almost anything but family court, and there's 5 sections on mediation. So if you don't quite catch on to anything we say today, it's in there. And I see it's so Suma's said happy birthday. She's written a book as well. Louisa, when are you going to write a book?
It is on my list of things to do this year. I'll keep you posted.
Thank you. Over to you.
So I'm an accredited mediator. I'm also a non-practicing solicitor. I practiced as a family solicitor until 2013 when I had a sudden rush of blood to the head and left and set up a family mediation practice. I'm also a PPC and a child inclusive mediator, and I do bits of training. And Joe and I are here today to talk to you about supporting the mediation process and how, as lawyers, you can make it work in the best way that it can. So if I share the slides, and this is very much intended to be a conversation, and we really want you to be involved. So please add anything in the chat and ask any questions that you have. We do have a question. Oh, it's all right. It just says happy birthday, Joe, in the questions.
I'm enjoying this. It's the most happy birthday I've ever had in my whole life. Anyway, carry on. Sorry, serious.
So we're going to be talking a bit today about the family mediation process and how it's set up, just so that you're clear on that. And I think it's probably worth saying at this point that as a lawyer, before I did my mediation training, I really didn't actually know that much about what happened in mediation. I could give clients my few sentences on what I thought happened, but I really don't think I had a very good understanding of it. So this really is a space where you can ask questions, and Joe and I are very happy to answer anything. There is no such thing as a stupid question. We're also going to talk about hybrid mediation and how you can best support the mediation process that your clients are in. We're going to talk about common pitfalls and how to avoid them. We're also going to talk about including the children, and then we will answer questions and answers, and we'll try and do that as we go through, as well as time at the end if we've got it. So one of the things that I find fascinating, Joe, is that if you go to any room of mediators, you will discover that there are far more ways to do things than you actually thought possible. Yeah. So I tend, when I set up mediation and we've had an inquiry from someone, to send out mediation information to both parties once someone gets in touch, before I've done an initial meeting or a MyAMS meeting with any of them. But I know that lots of people don't do that. Sometimes people meet with somebody and then contact the other person. So what do you do, Joe?
Yeah, I mean, I send out what I call a mediation information form, which I think lots of people must do, and that does give that starts the process of getting to know the client. And there is also, and we're coming on to screening in a minute, there is also a section about are you worried about the other person being in the room? Are you worried about, and it kind of starts the conversation, because of course we don't know these people and we're expecting them to tell us quite a lot about themselves, their lives, their relationship, and they don't know us from Adam, do they? Or rather Eve. So this starts that getting to know you process, I mean, I also send them out a workbook and other things, but and I think I think you're going to do the workbook soon, aren't you, as well?
Yeah.
Yeah. It's not about workbooks. I'll show you. And this is Our Family in 2 Homes, and the clients get that, and they can start thinking about what's important to them. But more important, starting the process of getting to know each other.
Yeah, absolutely. And you've already mentioned screening there, which is one of the most important roles that I think we have. And I think it's really worth saying that mediators really do look at all aspects of concerns in doing the screening process. So we're not just looking at, has there been physical violence? We're looking at, has there been emotional abuse, financial abuse? Is there an element of control? Has there been patterns of controlling behaviour? Is someone just really, really uncomfortable about being in mediation with their ex-partner? And if so, what is that? What are they worried about? And I know a lot of lawyers are really protective of their clients because you see them and you spend a lot of time with them. So it's understandable that you might think, oh, I don't think this client would want to go into mediation. I'm not sure this would be right for them. But please rest assured that we do have really robust screening processes, and mediators are all required to do domestic abuse training as part of the reaccreditation. And it's something that we do take very, very seriously. Once you've had those initial meetings, the people in mediation can then decide, right, I've heard more about mediation. Is this right for me? Is this what I want to do? Or having heard about other options, is there something that might work better? And the mediator says, yes, it's suitable for mediation, or no, it's not. Or sometimes what we might say is, yes, we think we can mediate, but we want to do X, Y, Z by way of safeguard. So that might be putting people in different rooms. It might be having support within the mediation process. And we're going to talk a bit about hybrid mediation. And there's lots of safeguards and different things we can do to make it work, isn't there, Jo?
There is, yeah. I mean, I'm taking a more a harder stance, I think, these days on where there is such a massive, there's been coercive control, which in many ways is more insidious than physical abuse, because the person kind of doesn't really know which way is up. I think the victim of that, and I think that I have to be really careful as a mediator not to reproduce that in the mediation. So I'm probably much less likely I'm more likely to say no to mediation than I used to be. And I don't know if that's just I'm getting older and I'm more protective, I don't know, or perhaps I just know a bit more than I used to. I mean, I do think it would be worth, I think the intake sessions are really important anyway, because as you say, they get to hear about the other things that might work for them. But also then the solicitor, the lawyer, can be sure that they've made the right decision about whether or not mediation is suitable, rather than just ruling it out. But yeah, I mean, I can understand why lawyers are so protective.
Yeah, absolutely. And I agree with you about the screening process, and it's always better to be cautious and do no harm than to kind of steam in there, definitely. And if everybody says, yes, this is what we want to do, then we move into joint meetings. And the question that we probably most often get asked is, how many joint meetings will I need? And that is very much how long is a piece of string? I always say to clients, well, it depends how many issues you've got to resolve. If you've got lots of issues, it will probably take longer than if you've only got 1 or 2. It depends on how emotional you feel in terms of how long there is between meetings. You know, I've seen people who separated 3 years ago and they come to a mediation meeting every couple of weeks until it's sorted because they're in a space to do that. I've seen other people that might take 6 months between mediation meetings because they have to go away, you know, and deal with how they feel after it. And also, I think it depends on how willing everybody is to compromise. I don't know what your thoughts are on that, Jo.
Yeah, I mean, I think the big thing is really for them to be ready for mediation. And I think working with a divorce coach, working with a therapist, working with any number of other professionals, and actually sometimes having those professionals in the room with us, I think can really enhance the process. And I think they're much more likely to do better more quickly with that extra help. Not that I'm not fantastic and you're fantastic as well, Louisa, but sometimes we need a little bit of help.
Yeah,
and they do too. Yeah.
I agree with that wholeheartedly. And I know that people think, oh my goodness, how much is this going to cost me if I'm paying a mediator and I'm paying a lawyer and I'm paying a divorce coach? But I think sometimes it helps to think about it as, how much will it cost me if I don't have the right person at the right time? And if, you know, spending, I don't know, £2,000 or £3,000 across a lawyer and a mediator and a divorce coach saves you spending £30,000 in a court battle. That's an extreme example, but you know what I mean. It's money well spent. And then if people want to, if they've got to an outcome that they want to put in place, as a mediator, we can draw up an open financial statement and a memorandum of understanding. And sometimes I think that's really helpful if the people have worked more with the lawyers than anything else, more with the mediator than anybody else, because it helps just to set the scene and explain the kind of background and why people have arrived at the conclusions that they have. So moving on to the next slide. Hybrid mediation. Now, Jo, you're hybrid mediation trained. Do you want to talk a little bit about this?
Yeah, so it's hybrid mediation or assisted mediation. It's where the lawyers are heavily involved in mediation. So the model that seems to have evolved in this country of family mediation is that the lawyer, the good lawyer, sends the client off to mediation, and they don't. I mean, we're going to talk more about this. They don't have much to do with the client, and then they turn up some months later. Oh, this is what we've come up with, and the lawyer scratches their head and said, "How on earth did you come up with that?" Well, this helps with that, any misunderstandings. The lawyer is part of the process. So lucky me when there's two lawyers who are instructed, then I can have a professionals meeting with them. What are you worried about? What are your urgent issues? How can we best help in mediation? And when that's sorted out, then we get together with the five of us actually, because I'll be there. We, essentially we just work through an agenda that we've agreed on. Of course, the lawyers really like it because I'm there helping everybody. Although I'm neutral, we're very organised. Everyone does what they say they'll do, and I know it can be difficult to arrange five of us on a Zoom or in person, but the lawyers generally will always make themselves available because they really like doing it. And why would someone choose hybrid mediation? Well, they might choose hybrid mediation because they really feel their lawyers aren't getting anywhere with toing and froing with letters, or things are getting quite heated between the lawyers, and perhaps someone needs to step in and calm it down. But more often it's that one person in the mediation process really doesn't have any confidence, and they really don't feel they can make decisions without having their lawyer there. Other times there's just one lawyer instructed and the other person's acting in person, the other member of the couple is acting in person, and that can be really hard for the lawyer to deal with. I'm sure you've all got experiences of trying to explain something to what we call a litigant in person. That's quite normal for the lawyer, but the person just treats everything they're told with suspicion. They don't trust the other lawyer, don't trust the lawyer, whereas the mediator can come in and work with the litigant in person and explain practice and procedure, and hopefully that trusted neutral professional gets over some of those hurdles. There's all sorts of reasons, and also, I think generally speaking, that's where I'm instructed, just to kind of move things on. And sometimes, of course, I can say, look, you're doing really well now, you don't really need me, and off I go. If we're mediating and the clients are with their lawyers or just one lawyer, I stop the clock. So I do other work. So I'm not charging for the whole time that we're together. I'm just charging for bits of time when I'm being used. Mm-hmm. So it doesn't have to be as expensive as it sounds. And I think all of us who do hybrid mediation would do that. One of the main differences is that I can keep secrets. It's called caucusing. Usually in family mediation, everything's open. But in hybrid mediation, I might go to one room with one lawyer and their client, and they say, I say, where are you with maintenance? And they might say, we'll go as high as this, but we're not going any higher. But don't tell them that. And I'll go in the other room and they'll tell me what their secret is on it. And because I have all the information, I can broker a deal. So it can be really effective at moving things on. So it's much more like the civil law model.
Yeah, and someone's asking a question: can you do hybrid mediation where one person has a lawyer and the other person is a litigant in person?
I think it's ideal for that scenario, absolutely ideal, because as I mentioned, the litigant in person really doesn't know what's going on, and they need that extra help, I think, from the hybrid mediator, and that really helps the lawyer who is instructed not to have to keep dealing with them all the time, which can be difficult.
Thank you. And one of the things that always blows me away about mediation, I don't know about you, is that sometimes people can have spent quite a long time with lawyers, or one lawyer and a litigant in person, corresponding about an issue. And when both people are in the same place at the same time, the speed with which you can clarify something that's been misunderstood is sometimes really quite breathtaking, isn't it?
It really is. And I think that's what's lost in solicitor correspondence, lawyer correspondence, is that instantaneous, the light bulb goes on. Everyone goes, oh, that's what that was about. And we can just move on.
Yeah.
Yeah.
And I agree with you that sometimes there are people who just, if they're going to have to go away from mediation and talk to their lawyer before they then bring it back again, having the lawyer present just cuts out some kind of, well, some steps in the process, doesn't it?
Yeah, you cannot beat contemporaneous advice. I mean, how lovely is that? You know, the clients with their lawyer, they feel safe, secure, they're getting up to date in the moment advice, and they can happily make decisions because the lawyer says, yeah, that's broadly okay. You know, I'm happy with that. And then everyone's happy with that at the same time. And because it can be so effective, you know, you can have legally binding documentation that emanates from the hybrid mediation session, because it's more like the civil model, so it can be legally binding. And sometimes that's the thing that stops people referring to mediation. So, well, it's not legally binding, but the lawyers will be busy drafting this documentation during the mediation, and we'll be signing up to it. So it can be really quick if you've got a deadline, and we know sometimes what those are. Yeah, tax, etc. Yeah.
Okay. So supporting the family mediation process, I think one of the key things to me is what you said at the outset, Joe, which is that sometimes clients say, oh, well, we're going to go to mediation. And so they almost drop out with the lawyer. And I know as a lawyer, sometimes it was kind of, oh, okay, and I'll just check in and see what happens. And I think there's a real advantage to talking to your client about how you can support them in the mediation process. And as a mediator, I will quite often say to people that both have lawyers, do you want me to copy your lawyers into the summary? Because it's much easier for them to advise you if they know what you've actually talked about in mediation and what the discussions are. And so often people say, oh, no, don't do that because I'll get charged for it. And I think that is the thing that people worry about most. What do you think, Joe?
Yeah, I think it's hard, isn't it? Because lawyers get charged for everything that comes in through their email box, or on the phone, etc. So it would be nice. Someone's lost audio. I don't know if anyone else has. Let us know if you've also lost audio. Yes, but I mean, Sarah Jelly, another great lawyer, mediator, she sends updates with the permission of her clients, which I think is a class act. And I don't do that because I think it's an extra cost for my client. Everyone can hear fine, thank you. So I suppose it's what the arrangements that the media has with the client. And I think Louisa hinting perhaps that there's a kind of don't charge for that. If that comes in, don't charge. Are you wondering that? Is that what you think?
I once said this as one of a number of potential options, and a lawyer that I know emailed me afterwards and said, yeah, no way. And I get that completely. You know, we need to think about the commercial realities. I think what's more important is for there to be an actual conversation, you know, whether it's just, okay, well, you might need some support during the mediation process. I could do, you know, we could have a meeting when you've had a couple of mediation meetings and go through everything, and this is what I will do and how much it will charge. It's just being clear about it, because I think so often people don't understand the way that lawyers charge. You know, there aren't many other situations in life where you get charged per letter and things like that. It is a slightly, if you've never instructed a lawyer before, I think it can be a bit of a shock to people. So I think just being really clear about how you could support them, what the benefits would be and what the charges would be can be really helpful.
Yeah, agreed.
And one of the things that I absolutely love about being a mediator, and why I don't think I could ever go back to being a lawyer, is that we hear both sides of the story. And to me now, I think it would feel alien to only ever hear one side of the story, because it enables you to fill in the blanks so much. You can see what's happened, what each person's looking to achieve. And I can't tell you how many times I've had clients come into mediation and go, we can hardly talk to each other, we're really far apart, this is going to be really difficult, I don't even know if we're going to be able to find a solution. And then when you ask them what their ideal outcome is and what's important to them, it actually turns out that they pretty much want the same thing. And knowing that can just be really helpful in terms of knowing that, you know, you can build on things in the mediation. What do you think, Jo?
Yeah, I think that's I think when acting as a lawyer or solicitor, you know, the training is to just represent your client and to put your client's best foot forward, if you like, all the time, and only really think about them. But we know that in the end, the judge will think about everybody, and the judge will hear from everybody if it ends up in court, or if the couple are sensible and go to arbitration instead. So in a sense, we're the lucky ones. We will always hear everything all the time. But it's quite interesting. You have those first individual meetings with the clients, and you hear their separate sides of it. And then when you get together, you go, oh, okay,
yeah,
everyone can understand what's going on.
And Sarah Manning yesterday in the session with Sarah Davison and Paul Linsell talked about how she thinks clients are more open with her as a mediator than they are as a lawyer. And that's definitely been my experience. And I can also point to a mediation where there was a really significant piece of personal information that was governing what the driver was in mediation and where both parties needed to be, but neither of them had told their lawyers. And I've always thought that the lawyers must have thought it looked very strange, the things that we were talking about in mediation, but they hadn't felt comfortable sharing this information with the lawyers. So I think that's something to be aware of, that sometimes something might have been shared with the mediator that hasn't necessarily been shared with the lawyer, and that might be part of the reason why things might look a bit strange. And check your understanding as well, which might sound a bit patronizing, but I think one of the things about mediation is that you can start a mediation meeting in one place and end a mediation meeting in quite a different place. So if you're advising someone, you could meet with them one week and then meet with them the next week, and actually what they're looking to achieve might have changed. They might have a whole host more information that has changed their thinking, and things can have moved on quite significantly. Is that something that you see as well, Jo?
Oh yeah, I mean, it's night and day sometimes. And on that basis, you know, the poor lawyer wonders what on earth's happened. But literally everything can change, and it can just turn around on a sixpence, as we used to say. I'm not that old, by the way. I was never old money. But it can really turn, and everything changes. And therefore, it's hard. I think it's harder for the lawyer to keep up, which is in many ways a great idea why they should be involved in mediation more than they are. But yeah, and then what we talk about, charging structure. Yeah, please, yeah, do check in and say, well, how did you come up with that? But sometimes the clients won't remember how they came up with that. They won't remember exactly what happened in the mediation session because so much happens. So they just say, well, I don't know. They might scratch their head and say, oh, I don't really remember. And then you're none the wiser, and it's a bit annoying for you. But trust us, something major will have happened, and it's a breakthrough moment probably.
Yeah, and that's why it can be helpful to have documents for mediation, because often it can explain the rationale behind things that they've arrived at, definitely. Okay, so being kept in the loop. Oh, that seems to have disappeared. Oh, here we are. So things that you need to know about. So what was discussed in the session, that can be a helpful thing to ask, because sometimes clients come to mediation thinking they're going to talk about one thing, and then something's happened the day before and they end up talking about something completely different. And that can sometimes be why things have moved on. And I think people's priorities and objectives can change as well. I've seen quite a few mediations where someone comes into an initial meeting and says, I'm not selling the house. I am not selling the house. That is my home. That is my children's home. I will not move them. Mm-hmm. And then by the time we've got to sort of say, let's say meeting 3, and they've kind of looked at what it will mean staying in the house and the compromises they might have to make in terms of, I don't know, working full-time instead of part-time, or they realise that their standard of living is going to be really, really much less than it was because of stretching things across 2 homes. And they might then come to a 3rd meeting and go, actually, do you know what? I've decided that really we should sell the house because it's better to just do everything now and then we can move things on. And again, that could be because some new information's come to light or somebody's discovered something they didn't know. I mean, you can probably think of other examples as well, Jo.
Oh, yeah. I mean, and I think that's that the lawyer has to be kind of think on their feet quite a lot because they're not going to know exactly how the client made such a seismic shift. And actually it might actually be against advice. The advice might have been, no, you definitely stay in the house. You can definitely stay in the house. Why shouldn't you? So they're going to have to be supportive of that big decision that their client's made, and not too worried about, and not worried too much about it.
Yeah. And sometimes I think curiosity is our favourite friend, because as mediators, we like to be curious, and we can do things that encourage people to share things, or we can do things like we suddenly purse our lips or we frown that can make people think actually maybe they're on the naughty step and they don't want to share things. And sometimes in mediation, I don't know about you, Jo, but you have to work quite hard at your poker face when people are sharing things.
Not judging.
Yeah, exactly.
It's my job not to judge.
Completely. So again, if they have had a change of direction, it's helpful to understand what precipitated that, what made someone change their point of view. Information assumptions. So do you have all the information? If somebody has made a bit of an about turn on what they were saying, what's precipitated that? Was there further information? Did something just change in how they were thinking about it? And the mediator sees both parties together, and that really enables us to understand the dynamic between the people. And what I think is really interesting, I've talked about this with some of my consultees as well, is that people can present one way in the initial meeting, and then when they come into mediation and they're together, they can almost become completely different people because of the way that they interact with each other. Does that make sense to you, Jo? Have you seen that?
Yeah, I mean, the dynamic of the relationship, and obviously it's our job to try to manage that. Any power imbalances, if they behave in a way, but also not to be the teacher, because usually, I mean, in insight mediation, which is what I practice, the idea is that if people are being defensive, i.e. they're interrupting, they're shouting, they're not talking, they're crying, all of these things are defenses that uncover actually something really deep and meaningful to the client. So it's our job to be really curious about that, not to tell them off and say, don't be like that in my mediation session, although that's really tempting. It's like trying to draw out what's the block, what's stopping them.
Yeah. But also, we always have to be alive to the kind of power imbalance and the control elements, but sometimes it is just how people get on. I mean, I remember a mediation session once where for about an hour, not a lot happened other than they were each explaining why they thought they were right. And then the last half an hour was literally a kind of Wimbledon tennis tournament of negotiations back and forth. And I stopped it at one point and said, look, this feels really pressured to me. And I don't think that it's helpful to make these decisions like this. And they were both very clear that they felt very comfortable with it. This was the way that they both approached negotiations and how a familiar dynamic in their relationship. And they were both very comfortable with it. So as a mediator, my role is then to get out the way and let them help and just provide the information. So it can be quite interesting watching that kind of thing develop.
Yeah.
And as I've put there, which I think we've sort of already alluded to, but mediation sessions provide live questions, answers, reassurance and discussion, and things can change very substantially. So someone can come into mediation having a real fear about something that has been driving everything that they have been negotiating. And actually someone just says something that makes them think, oh, actually, I feel reassured now. And all of that barrier can just fall away.
Absolutely. Absolutely.
So, and talking about understanding. So I think it's just always worth saying that ensure you've got all the information first, because sometimes there can be updated financial disclosure that's been provided in mediation that might substantially change how you were talking about things before. Things can be worth more than people thought, less than people thought. And their joint priorities and objective can also change, and so can the direction they're going in and the understanding of things. So I think understanding things first before you give the advice can be really helpful in sort of painting that picture of what's been happening in mediation. Would you add anything to that, Jo?
Yeah, it just that because I'm still a practicing solicitor, and I think our training, it's really hard not to, and we'll talk about this in more detail. It's really hard not to really take your client's side. It's really hard not to be gunning for them and really, what are you doing that for? No, but that's, I suppose it's to suspend disbelief a little bit as the lawyer, and keep digging about, being curious about how they came up with it. Even if they don't know, just think, broadly speaking, is this okay? And I think it's I suppose we're sort of begging solicitors really not to try to undo all the work that the couple have done. I think that's probably a lot of this session is about, trying really hard not to do that. But I know it's hard. I do know that.
I understand that completely, the kind of protective element. I mean, I often talk in mediation about, there's a bracket of what's reasonable, and at one end there's what's best for one person and worse for the other, and then the other end is the reverse. And as a lawyer, you're always going to try and get your client towards the end of the bracket that's better for them, because you want your client to do well and you want to protect them and look after them. But the other person's going to try to go to the other end of the bracket. So if they've managed to find something that's midway through, then there may be valid reasons for that. If they're trying to do something that's well out the other end of the bracket, then you might be having a slightly firmer conversation with them, perhaps. So charging structure, just to talk a little bit about this, I mean, it's what I was alluding to before, that if you can support mediation with a fixed fee, I think it helps clients to kind of understand, right, okay, so I'm in mediation, but I know that I can pay this amount and my lawyer will look at the mediation stuff I've got, give me a meeting to talk about it. And that seems like it's a doable cost. It's not this kind of unknown entity. And as I talked before, I did suggest once that, you, as a lawyer, you could be copied into the mediator summary, and then you would only need to read it if you were doing the work for the client. But I know there's a big concern there that if someone's sending you something and you haven't read it and it contains a massive, great, I'm trying to think of a good metaphor, that's something that would be a cause for concern. So I do understand that. But what I mean is, how can you work together with your client in a way that they understand and they're happy with? What would you say to that, Jo, since you're still practicing as a lawyer?
I mean, look, I think the market is very tough. I think the way that we're working is changing so quickly, and tech is coming along biting us from behind. And we know from the Fair Shares report and other research that people are just not going to solicitors and lawyers anymore the way that they did. And they're really frightened about the cost. And that's why they're not going. But as it turns out, the research shows that actually the cost wasn't prohibitive and actually was not that expensive. And I think I'm hoping that all of us can have a conversation about costs with our clients, rather than the structure at the moment, which I'm not against it, of course, because that's how I make my living do. I charge in that way, but to be feasible, to be able to keep going in this job. I mean, look, I think it's something like 20% of people go to a solicitor or lawyer. When I qualified literally 20 years ago in June, 80% of people went to see a solicitor when they broke up. Or they were thinking about separation or divorce. So this is it's been a complete change, and we're hanging on by our fingernails. And I think I don't want to be depressed on a dreary Tuesday, but I do think we have to think seriously about what we're doing and how we're doing it and what we're offering and how we think we can be more competitive, but still make a living. And I think that's important. And I think the way that if you say to your client, look, I'll support you in mediation, you can pop in and out, tell me, update me before a session, I can advise you, see me after a session on the phone, call me on the phone, or send me whatever the mediator's prepared, and I'll advise you as you go. And you could think about a fixed fee for doing that, and certainly a fixed fee for drafting at the end. I think that would be really helpful for the clients. I mean, I don't draft the documents because most of my clients are referrals from other solicitors, and I don't want to bite the hand that feeds me. Some mediators will do that drafting work, but I'm generally opposed to that. But that's just my personal view. I think let them go back to the solicitors. But if they've had no advice, who's going to do the drafting for them? Well, I might send them to somebody who will draft everything in one go. With my other hat on, it's not quite an advert, but if you're a mediator and you're sending your clients, I do offer a one lawyer service for a fully mediated agreement and a fully financial, where all the financial disclosure is done, and there's a memorandum of understanding. I will do a fixed fee for the clients, and I can act for both of them. But if you're referring to the one solicitor or resolution together process, check with your insurer because it's one neutral person followed by another neutral person. and that might cause some problems from an insurance point of view. But thinking creatively, how can we get clients where we need them to go, engage our services, all of our services, mediators and lawyers, and give them a good value. That doesn't mean cheap, it means good value.
Yeah, absolutely. Yeah, the question in my head is always, how can we best support the clients in front of us? And certainly I echo what you say about people not going to lawyers. I mean, I started my first job as a paralegal in 2001, and people used to come in, tell you they were separating, then they'd write you a check on account at the end of the meeting. Even by the time I left legal practice in 2013, people were, well, I'll get some advice, I'll go away, then I might come back. And even in the 10 years that I've been running a mediation practice, the number of people coming to us directly for mediation, having not seen lawyers, has increased quite a lot. And what I think is a bit worrying sometimes is that I see people who won't go to lawyers. And even when you explain about formalising things, what they need to do, you know, particularly if there's got things in place with pensions and they want to put a pension sharing order in place, having clients who say, well, we don't want to go to lawyers, lawyers will make us fall out, they will undo.
Yes.
And I say, no, they won't. Not if you go and see good lawyers. You can go and see people. I can give you some details of people. You can find people via Resolution's website, all of these things. But people really worry about it. And I don't know whether that's something you've encountered or what you would say to that. People
are terrified. And a little pause there, because I think that's something we've got to really think about, because doing the lawyer or solicitor job has ended up alienating lots of the public. So there has to be a way that we can do something about that, because clients need lawyers.
Yes.
Clients need solicitors. They need that advice. They need good advice, sensible advice, not uber positional taking advice. There's no point in that, because the more experienced you are, the more you know that actually you need a solution that's going to suit everyone in the family, not just your client. And we as practitioners have to think more in that way and less in that kind of blinkered, this is the way we get the most for you. That's not what this job is about. Not for me, anyway.
Yeah, absolutely. I agree with you wholeheartedly. So let's talk a little bit about mediation funding. So legal aid is available for family mediation for all those that qualify. And we also have the mediation voucher scheme, which means that couples who want to talk about arrangements for their children can claim up to £500 towards the costs of their mediation. So that pretty much covers one session. With most mediators, I think sometimes there's a balance towards a second session. It depends on the charges that there are. And the mediator needs to be registered with the scheme, but there's lots of mediators around. And obviously with online mediation, it's a lot easier for people to access mediation. And I just think, I don't know about what your thoughts are, but the mediation funding scheme, I think, has been really helpful in encouraging people to take a punt on mediation. So they might think, I don't know whether it's going to work. I'm not sure I want to sit in a room with that person, but do you know what? It's not going to cost me anything to do it, so I'll give it a go. And I've certainly seen people who say, well, I'm doing this before I go to court because I've got to show everyone I'm being reasonable, but I'm going to court after this. And after one session, they've actually heard enough that's persuaded them they don't need to go to court. What's been your experience, Jo?
Yeah, I mean, I think the only thing I would say is that it's a shame it doesn't cover those first meetings that we say are essential. It's a shame that the Ministry of Justice hasn't picked up on that, because I think that screening is essential, those first meetings, which are not covered. And the voucher also doesn't cover any preparation work that we do as mediators. So it's literally just work in the Zoom room or just work in the room. Obviously, it's the most experienced mediators that are doing it, that offer the service, because you have to be accredited. But yes, it does cover a meeting, and sometimes that's enough of a taster, or enough for them to know actually mediation isn't suitable. They actually do need to use their lawyers. So it's not, it can work both ways, but they will get to hear more about their options, I think, in these sessions.
Yeah, definitely. And I think we all know that, is there such a thing as the perfect system? Probably not, but there are definite, barriers in terms of, if you're not eligible for legal aid and you don't have any spare cash at all, it is hard to find that money for MIAMS. What I think is interesting in the stats on the mediation voucher scheme is that for those who've partly funded a bit themselves, i.e. they paid for a second meeting or something, the success rate goes up even more, which I personally think is quite interesting.
Someone's asked, is the voucher scheme due to finish? It's been extended and a new contract been given to a supplier to provide scheme for how many, I'm not sure how many more years. Maybe one of our friends, Beverly Sayers here, is an expert, and Helen Anthony here is an expert on how long that contract was. But the scheme before was kind of very stop-start. We didn't know if it would be continuing, but I think the government's really likes it and is really supportive of it. Oh, 2 years. Thanks, Beverly. Beverly Sayers saying to everyone. So there's 2 years to go on the scheme. I suppose it will depend on if we have a new government, if the new government, if it wants to continue to support it, if we have a change. So yeah, we don't know, but 2 years is quite a long time, and I think certainly you can be still referring to it. We've got another question. Is that all right if I take that as well?
Yeah, go for it.
So can mediation with lawyers be funded under legal aid? No, I think is the answer. We support clients usually connected with domestic abuse under legal aid, yeah, and then develop the disputes over child arrangements, and usually mediation is not considered appropriate, but it would be good to know if this could be an option. I think that's a great idea. Have the lawyer, if there's domestic abuse, have the lawyers there in a legal aid case. I'm not sure if the legal aid budget for the solicitor would run to it. I think there's a fixed fee for it, and I don't know if they would do it under that scheme, or if they would even be allowed to. If there's any legal aid lawyers on here, perhaps they would let us know. Or do you know, Louisa?
I don't know. My instinct says that I don't think it would cover hybrid mediation. Knowing it, I know a little bit about legal aid mediation. I don't do it, but I'm in a group with lots of people that do, because the amount paid under legal aid for the meetings is pretty small. I was going to say, just with regard to the voucher scheme, that was part of the consultation last year on mediation about the voucher. So when we have the release of the information following the consultation, it will be interesting to see whether there's anything about the voucher scheme in that. So, common pitfalls and how to avoid them, because what's the point in knowing about a pitfall if you don't know how to fall into it? So I think probably the chief thing that I have spoken to lawyers about over the years I've been a mediator is that awful situation as a lawyer where a client comes in, yeah, I've done mediation, we've sorted it all out, and here's an MOU, and you look at it and your heart sinks because what they've put together is something that you think is unworkable, or is something undraftable, yeah. And I think, firstly, this is why it's so important to be there during the process, and why as a mediator I am saying to clients a lot, well, do go and talk to your lawyers. If there's anything you don't feel comfortable with or you're not sure about, do go and have a chat, because it's much better if there is an issue that we know about it now rather than it coming in at the end. So I think that supporting the process rather than just having someone come back at the end can be really helpful in that. And trying to understand what they were trying to do, because sometimes there's the intention there, and if you start with the intention of what they're trying to achieve, then that might help you to kind of save the situation by looking at it in a more workable way. What would you say, Jo? Have you been in that situation where you've got an unworkable MOU?
I have. I mean, I tend, as the solicitor getting one or drafting one, I try not to draft them like that.
I'm assuming neither of us are drafting these things. But,
I mean, I think once there was a situation in mediation where there was a refusal to share the pension, and we know that pensions really must be shared. They're usually a big asset. Please don't give them away. And that's what happened in this scenario. And I tried to write it as if to say, I told them this was not fair and they shouldn't have done it. But the solicitor didn't see that in, and the solicitor phoned me and said, well, why have you done that? And I said, well, obviously I didn't do that and I'm against it. I think now, some years down the line, I would say no. I don't think that's not something the court will order. So I would say no to it. And I think that, I hope that doesn't go against all the principles of mediation, but I don't really want my clients to get into something that is unworkable. Well, what do you do? I think you're right. You try to get to the bottom of what it's about, and it might be that they there was a compromise that's invisible, that perhaps isn't financial, but obviously you have to, you know, as the solicitor trying to get the court order, the consent order as it would be made, they really need to know the whys and the how, so that they can sell it to the judge, sell it to the court on the papers. So I think, yeah, I mean, I think sometimes, and that's where power imbalances can come in. You know, we have to be really careful that people don't just give up, because let's face it, you know, what they were like in their relationship, they're going to be like that in their mediation. They're going to be like that in their negotiations through their solicitors, whatever process they use. They just keep mimicking this dynamic. So yeah, this is very difficult, and you know, I think the more experienced as practitioners, you know, the more we'll see it, and the more we will do everything we can to not let it happen.
Yeah, and I mean, I am always very clear with clients, and I think we should be, that if they're trying to agree something that is outside of what a judge would order, or we think it might be, I always say to them, you need to go and get legal advice, because I'm not sure that this will be something that could be approved, and there's no point you investing time and money and effort in mediation if what you're coming to isn't going to be put in place. So I think as mediators we should be clear about that. The not having dealt with all the assets, sometimes people just forget that they've got something, or they had a pension from mum ages ago that they didn't think was worth anything, and it turns out it is worth a lot, and no amount of us saying make sure you've got everything seems to prompt that. That can be a difficult situation to be in. And I agree with you, Joe, about the power imbalance. There's definitely something that I see as the guilt giveaway, where someone feels really bad because they've ended the relationship, or they've met somebody else and they're like, no, have everything, please have everything. And, you know, explaining to people, well, you both need to be housed, you both need to be able to make ends meet, otherwise this really isn't a realistic solution. And I think one of the pitfalls as well is the client not sticking with the process, and that's quite a tricky conversation to have as a solicitor, when your client says, oh, it's not working in mediation, I really think I might need to go to court, or I might need to do something else. How do you handle that, Joe?
Well, I think that sometimes that happens, doesn't it? There's sort of fatigue. There's all sorts of reasons. I mean, I think that would be a good time to invite the lawyer into the process, and make it hybrid. I mean, I use a hybrid agreement to mediate, so that I can have the lawyers in really easily and really quickly. They just have to sign the agreement to mediate, and they just need to be supported. They just need that little bit of extra support, or perhaps they need it from somewhere else. You know, again, family consultant, the divorce coach, the therapist. But if someone doesn't want to do it, you know, everyone's a volunteer in mediation. So if they don't want to do it, it's over, and they don't have to give a reason. I think that's probably fair enough.
Yeah, I agree. I mean, I think there's always a conversation to be had about, was it just a really difficult meeting? Has something just touched a nerve, something that you're frightened about? You know, sometimes people say, that's it, I'm definitely not coming back. And then 2 weeks later, you get an email saying, actually, I think it would be helpful to set it up. So I always think it's helpful to know what motivated that. But if it's that things aren't working, or they're just finding it really difficult because they need other support, then absolutely, how could it work better is the question to ask. So unworkable MOUs, I think we've covered all this through, really, you know, not having been kept in the loop, sending clients away. And I think the question sometimes is, what would make the client talk to you during the process? And actually that's a question to ask people, what would help? And mediators flagging discussions that are outside of court terms, I really believe we have a duty to do that. I think it's unfair for people to sit there and talk about doing something that is completely unworkable. And I think talking about should be an understanding of all involved. If you're referring to a mediator that comes back with these kind of things, you know, there can be isolated incidents or something, but if this is a common problem or something, is there a conversation to be had? Is there a mediator that might work better with your clients? You know, it helps to think about which mediators you're referring to. What would you say, Joe?
Yeah, I mean, it's different horses for courses, isn't it? I mean, it's, you know, sometimes they don't connect with their mediator, and they need to try another mediator, and that might be something to think about. But yeah, I do think it's, and someone's put in the chat, you know, they had the problem of really unworkable solutions hitting their desk. and they're sort of wondering how that happened. And I mean, I think that's where the lawyers and solicitors have to think really creatively about how they can engage their clients to have more contact with them, not less.
Yeah.
So although mediation is cheaper, I do this, it shouldn't be cheap. I don't think mediation should be cheap. It should be good value, but it's best value when solicitors work alongside, support it, you know, are cheerleaders for it really, and supportive of what clients end up deciding to do. It's very hard for clients to mediate if they've got a very negative lawyer in the background saying, no, that's ridiculous, why are you doing that? Whereas, you know, there's different ways of saying that without ripping it to shreds. But finding, and I say, you know, and your ideas there, you know, for fixed fees, for not charging for this and that, but just to keep yourselves in the loop, I think is really important.
Yeah, and I think language matters so much. And for anybody that hasn't seen the full timetable for this week, there is a language matters session, I think tomorrow.
Yes, it is tomorrow. Yep.
So, and missed assets, again, there can be different reasons for this. So in mediation, we will talk about all the assets that have been disclosed, but if somebody's missed something or forgotten about it and we didn't know about it, then obviously we wouldn't be able to deal with it. And I don't think it happens very much, but it can sometimes happen that somebody has just genuinely missed things rather than it necessarily being a deliberate attempt to avoid, although we do know that happens. And did both parties understand their options? Is there a reason they decided not to disclose? Sometimes people genuinely don't know what they have. And I think people get so confused with pensions. I've encountered a number of people who think that when they left a job, they left the pension and the pension doesn't still exist for them. They don't know that they can still access it. And if there was a mixed asset, it could just be that if you talk to the mediator and go back into mediation, then you might be able to resolve the whole issue. Was there anything you wanted to add, Jo?
Yeah, I mean, mediation is not a soft option when it comes to financial disclosure. It really isn't. Although I don't, it's not the mediator's job to forensically check the disclosure. But the mediator should check that everything is there. So there's 12 months of bank statements or whatever. It's their job to point that out. I mean, some solicitors and lawyers practice in a way that they do they do the financial disclosure themselves. That happens between solicitors. They ask the questions and reply to the questionnaires, and then clients come to mediation. So that is another option. I mean, I offer that service, and so do you, Louisa. So you know, I create a Form E bundle. So I've got all both forms in one. It's an e-bundle, obviously, which is, you know, indexed and page numbered, and you know, and they have a list of what's missing. The clients know what's missing, and then I keep at that. Really, I think missing assets is, I mean, because you've forgotten them is one thing, but I do think they have a full, you know, they have an ongoing duty of full and frank financial disclosure. And I don't think that's watered down, and it shouldn't be watered down in the mediation process. But occasionally, yeah, accidents will happen, but it's not, you know, if it's not malicious, I'm not too worried.
Yeah. And there's a couple of things in the chat. Someone shared a really useful video to pensions, and someone else is asking about mediation training. And there is a session, I can't remember exactly when that one is, but there is a session about qualifying as a mediator. So
yes,
definitely
that's today.
Yes.
That's today. Okay. Yep, that's later today. And then mediation keeps somebody as first ADR training. Would you advise going for that or collaborative or one lawyer? I think you should do all of them, actually, Sophie, because that's what I do. I do all of those things. I do mediation and one lawyer and collaborative. And I think if you're going to be a solicitor, I think you really need to do collaborative and one lawyer. But if you're not going to be a solicitor anymore, then obviously mediation's the way to go. I'm
conscious of time, Jo. We've only got about 5 minutes. So clients are not sticking with the process. As we said, I mean, if they have a lawyer instructed, if something's happened in mediation, you are likely to be the person that they first call, and this is a really important call. So it could be that they've got unrealistic expectations of what they were looking to achieve. It could be that they're just finding being in a room with their ex-partner too hard. They may just be emotionally overwrought, or maybe they've lost faith in the mediator or the process for some reason. realistic expectations, I think we've touched on this, Jo, that kind of positional advice about if you have a client that comes into mediation that thinks that they're definitely going to get 61.45% of the family home and they will not deviate from that, it makes it much harder to mediate. Is it repairable? Is it just they need to blow off some steam and think about it, and then they might look at mediation again? Or if it's broken down and you're looking at next steps, then is there something else that you could do? Could it be a hybrid mediation, as Jo suggested? Could it be that if you've only got an issue that's maybe one issue that's keeping them stuck, could you look at an arbitration or an early neutral evaluation or something like that? What would be most helpful here? Helen's saying the How to Become a Family Mediator webinar is this afternoon at 4:15, and Language Matters webinar is tomorrow at 9 a.m. So I think giving realistic advice. Jo, do you want to talk about this since you still give advice?
Yeah, I think, you know, you've got to be, and I thank Mary Shaw for this expression, got to be deeply helpful for your clients. There is no point sending them off on an unrealistic case that they might get if they got a judge or an arbitrator with a full moon and a following wind, and they loved this person that they would get. That just got, the advice has got to be realistic, and that means you have to have a lot of confidence, because you have to think, you have to say, okay, I think this is probably your absolute best case. I think this is really the worst case you should go for. And you know what, actually, I think this would be all right. I think you've got to give them that spectrum of advice rather than just their best case, because if all you do is give them their best case, and I know you have insurance and you have to worry about that, but you can give your client all of those scenarios, but also encourage them to be flexible. So in your first meeting with your client just wants to know that they're going to be okay. I don't think they don't need to know that they're going to get the vase. You know, they don't need to, you know, or what percentage of the house they're going to get. I'm not sure that's helpful. I know that's really hard to take a step back from that kind of advice giving, but if you're going to really support mediation or really support any of these processes that are not letter writing in court, that's the way to start thinking.
Yeah, I always think it helps to sort of explain some basic principles, like everybody needs to be housed somehow and everybody needs to be able to pay their bills. Those are the kind of fundamentals. And for the vast majority of people, that is the situation. It's not, you know, most people that come in are not, well, who gets the home in Cannes and who gets the New York apartment and all of that. You know, most people every day, it is about making sure that both people are housed. Right, let me stop the slides there. And if we just pick up on any last questions we've got before we finish, I don't think there's any more in the Q&A. And the chat, no, Helen's given the link there. So if you hadn't looked at the rest of the events, then there's a link there. Sushma's saying to remind lawyers that clients work hard to reach resolutions in mediation that they can both live with, and sometimes it's not in line with legal advice. I think that's a really important point, actually, that sometimes people, and I see this in mediation quite a bit, people say, well, my lawyer's saying this, but in order for us to keep a friendly working relationship, I would be prepared to depart from that because I can see that, you know, you need this for the kids or this would be better. And so they may have taken that decision for very valid reasons. Any thoughts on that, Jo, before we finish?
No, I think that's absolutely right. And thanks for reminding us about that. I think legal advice needs to be spectrumy. It needs to be broad. It needs to be encouraging. It needs to be not, this is what you must go for. And not to be so excited that they can get an extra five. I mean, you know, I talk to sort of quite young practitioners and they're like really excited that they got their clients an extra £5,000 out of the settlement. But at what cost? At what's the emotional cost for winning that little bit of money? What's the emotion? What's the actual cost in legal fees, etc.? And I think I just think if you've been practicing a long time, you realise that you know, how can this family move forward, and how can you support this family to move forward?
Yeah, and I think my thought on that would always be, what's the impact on the children? So yes, you might have got another £5,000, but if the relationship between the parents is now really frosty, you've potentially got children in the middle of that who are having to navigate the fact that mum and dad now don't speak to each other, and dad grimaces when you mention mum and mum cries when you mention dad. And just to kind of reiterate that, I think it's always important we hold the children in our minds when we're giving this advice, because yes, you have to give financial advice, but sometimes that's the reason people move from it. and to remind people that it is always possible that children who are maybe 10 and up can have their say in the mediation process, so that they do feel their voices are heard and their parents are listening to them. And that can be a really important part of the mediation as well.
Yeah.
Right, well, we are at 10 o'clock now, so thank you, Jo, and thank you everyone for coming along. We're really glad it's been such an informative session, and we hope you enjoy the rest of Family Mediation Week. So thank you, bye-bye.
Thanks, everybody.